what we've tried to do for several years is to work with several of these companies to try to get them to do the right thing, maybe adopt some best practices. And that's my hope. I mean, litigation takes forever, and we would hope they would come forward and come forward with some proposals, but we haven't gotten there yet. So we're going to prepare for the worst case scenario. And there's legislation, there's litigation, and then there's some kind of settlement, which is the easiest and quickest way to get it done.
So in the case of Google, for example, are you looking at an antitrust case to build here or other aspects of their business practices?
Antitrust, the privacy angle. We attorneys general have authority under the Consumer Protection Act to do both, and so it'll be a multifaceted suit, or hopefully the settlement if we can reach some agreement with them. We have to look at tech companies like we would any other business. They have a duty to protect their customers, and they were strong enough and powerful enough when Section 230 of the Communication Decency Act was put into place to give them immunity, and they've abused that. And so that's caused the problems where they don't have it. They don't think they have any duty to protect consumers' information. So, at some point, if we don't have successful legislation, at some point, some court is going to rule to the effect that a person's private information is the equivalent of their intellectual property, and that the companies have to pay people for it.
Sir, there's a lot of issues there. My question is, what does size have to do with the protection of consumers' data? I mean, all of this latest round seems to have come up because of Cambridge Analytica, which is a tiny little operation that had a whole bunch of data from Facebook. A small operation could abuse consumer data. So why big tech companies? Why not pursue something more specific around the use of data, and even smaller companies be involved?
Well, the big companies control the data, and that's, again, the problem with the antitrust side. They're the ones that control the pipeline, and so, they have the duty to protect that information, as well as do the other smaller companies. I want to see us do some things like, if you download an app, for example, you have to opt in to allow them to mine your data. Now, I'm in litigation with Google, for example, for mining the data of our children when they sold our schools the so-called free package of email addresses and so forth. And then they would call them, and that they mine the data of those children, which is the most valuable asset in today's times. It's the equivalent of gold, particularly profiling a young person they can advertise to for the rest of their lives. And that's the economic issue that we're trying to address.
Last question, Mr. Attorney General, and it's about the tobacco precedent as well. Multistate agreement obviously netted billions and billions of dollars. Is that something that could also be a roadmap for what you're pursuing here? And would this money ultimately wind up in the hands of users or in state coffers?
Well, I think it needs to go back to the people that they've wrongfully taken their personal information. And, the states are having to bring it. Of course, there'll be penalties involved as well. I don't know how this comes out, but at some point in the future, there will be a reckoning. It'll either be in Congress or in a court of law. And the companies that are in leadership positions should step forward and let's try to develop some best practices, sort of like the regulatory scheme developed by the EU.